Delaware has a moderately regulated tenant screening environment with several state-level provisions that go beyond the federal baseline, reflecting the state's generally balanced approach to landlord-tenant relations. The governing framework includes the Delaware Residential Landlord-Tenant Code, found in Delaware Code Title 25, Chapter 55, along with FCRA and the Delaware Fair Housing Act. If you're screening tenants in Delaware, you need to understand both the federal requirements and the state-specific provisions that affect fees, source of income, and fair housing protections. Let's start with application fees. Delaware does not have a specific statutory dollar cap on application fees. The Delaware Residential Landlord-Tenant Code does not specify a maximum screening fee amount. However, the code's general provisions and Delaware's Consumer Protection Framework establish expectations of reasonableness. Fees should be proportionate to the actual cost of screening, and charging excessive fees that significantly exceed the cost of obtaining reports can be challenged. Most Delaware landlords charge between $25 and $50 per applicant. In competitive northern Delaware markets, particularly Newark and Wilmington, applicants are accustomed to paying screening fees. In more affordable southern Delaware markets, keeping fees moderate is practical. Criminal history screening in Delaware is not subject to a comprehensive statewide ban-the-box housing law with the step-by-step procedural framework found in places like Washington, D.C. or Chicago. However, Delaware has enacted reforms that affect how criminal records can be used in screening. Delaware expanded its expungement provisions in recent years. Under Delaware Code Title 11, Chapter 43, more offenses are eligible for expungement, and the process has been streamlined. Mandatory expungement is required for certain categories of records, including charges that resulted in acquittal or dismissal. Once a record is expunged under Delaware law, it should not appear on a background check, and landlords cannot consider expunged records in screening decisions. Delaware enacted a comprehensive ban-the-box law for employment, the Delaware Chance to Compete Act, but this applies to employment rather than housing. While the housing context isn't directly covered by the same statute, the overall policy direction in Delaware favors limiting the use of criminal history in ways that affect individuals' opportunities. Landlords should be aware that the political environment in Delaware, particularly in Wilmington and Newcastle County, supports additional protections, and housing-specific criminal history restrictions may be enacted. Wilmington has been active in tenant protection discussions. As Delaware's largest city and a community with a diverse population, Wilmington's political environment supports tenant protections. Landlords in Wilmington should monitor local developments that may affect criminal history screening. Delaware legalized recreational marijuana, and landlords should not use marijuana possession or use records as a basis for denial for conduct that is legal under current Delaware law. The Legalization Act includes protections against adverse action based on legal marijuana use. Landlords can still prohibit marijuana use on the premises through lease provisions, but using historical marijuana records to deny an application when the underlying conduct is now legal creates risk. HUD's 2016 guidance on criminal history and disparate impact applies in Delaware. Wilmington and Newcastle County have significant African American populations, and criminal history policies that disproportionately affect minority applicants face scrutiny under federal fair housing law. Delaware's small size means that fair housing enforcement is concentrated and efficient. The state's enforcement agencies have manageable caseloads and can give individual complaints meaningful attention. Documenting your criteria and applying them consistently is essential. Source of income protection in Delaware is well established at the state level. Under the Delaware Fair Housing Act, found in Delaware Code Title 6, Chapter 46, landlords cannot discriminate against applicants based on their source of income. This includes housing choice vouchers, Social Security, disability payments, veterans benefits, and any other lawful source of income. Delaware's source of income protection is statewide and applies to all landlords. Landlords cannot reject applicants solely because they receive housing vouchers. Landlords cannot advertise that they don't accept vouchers or government assistance. And landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's personal contribution would cover the rent. The Delaware Division of Human Relations investigates source of income discrimination complaints and has enforcement authority. Fair housing testing occurs in Delaware, particularly in Newcastle County, and landlords who discriminate against voucher holders face enforcement action. For credit reports, Delaware follows FCRA requirements for permissible purpose and written consent. The adverse action process follows federal requirements. Delaware does not impose dramatically different credit screening procedures from the federal baseline, but the state's overall legal environment expects thorough documentation of screening decisions. Delaware's fair housing protections under the Delaware Fair Housing Act are broader than the federal baseline. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, creed, and source of income. The breadth of these protections, particularly the inclusion of sexual orientation, gender identity, marital status, age, and source of income, creates a screening environment that requires careful attention to every aspect of the process. Delaware was among the earlier states to add sexual orientation protections, and gender identity was added subsequently. These protections are well established and enforced by the Delaware Division of Human Relations. The age protection means landlords cannot discriminate based on age, though legitimate criteria like income verification and credit history remain permissible. The marital status protection means screening decisions cannot be based on whether an applicant is single, married, divorced, or in a civil union. The creed protection provides broader coverage for belief systems beyond traditional religion. Delaware also has specific protections for victims of domestic violence. Under the Delaware Residential Landlord Tenant Code and related provisions, landlords cannot deny applicants based on their status as victims of domestic violence or based on incidents at prior tenancies attributable to the perpetrator. Delaware's protections for domestic violence victims in the housing context are well-defined and actively enforced. Delaware has a notable provision regarding the anti-retaliation framework. Under Section 5516, the code creates a 90-day presumption of retaliation if a landlord takes adverse action after a tenant exercises a legal right. While this primarily applies to existing tenancies, it reflects Delaware's balanced approach, protecting tenant rights while not creating the extended presumption periods found in states like Nebraska and Iowa. From a practical standpoint, Delaware has a small but tight rental market shaped by its strategic location between Philadelphia, Baltimore, and Washington, D.C., and its status as the corporate capital of America. Newcastle County, the northernmost county containing Wilmington, Newark, and the Philadelphia suburbs, has by far the state's strongest rental market. Wilmington's economy is driven by financial services. Delaware's favorable corporate laws make it the legal home of most Fortune 500 companies, and the banking and credit card industries have a massive presence, including Bank of America, J.P. Morgan Chase, Capital One, and Barclays. Healthcare, including ChristianaCare, the state's largest private employer, the legal profession, chemical industry, DuPont's legacy and its successor companies, and government also drive demand. Wilmington's rental market is moderate with steady demand. The city has a diverse population, approximately 60% African American, and criminal history and source of income screening criteria must be carefully documented and consistently applied. The concentration of financial services and legal industry employers means that a segment of the applicant pool has strong credit and income profiles, but the city also has significant lower-income neighborhoods where housing assistance is prevalent. Newark, home to the University of Delaware, has a tight student-driven market. UD's enrollment creates strong seasonal demand and a high volume of applicants with limited credit and rental history. Screening students requires consistent cosigner or guarantor policies. Newark's rental market also includes non-student demand from nearby corporate employers and Christiana Hospital. The Wilmington suburbs, including Pike Creek, Hoccasin, and Greenville, command premium rents driven by excellent school districts and proximity to corporate employment centers. These suburban markets have strong applicant pools with well-qualified renters. Dover, the state capital located in Kent County, has a moderate market driven by state government employment and Dover Air Force Base. Dover AFB is a major military installation, home to the largest aerial port on the East Coast, and generates significant military rental demand. Military tenants represent a substantial portion of the Dover area rental market. Landlords should understand military income documentation, leave and earning statements, and BAH rates. Dover's BAH rates are moderate. Dover's market is more affordable than Newcastle County and attracts both government workers and military families. The combination of stable government and military employment creates a reliable tenant base. Kent County also includes smaller communities like Smyrna, Milford, and Harrington, with modest rental markets driven by agriculture, poultry processing, Delaware is a major poultry-producing state, and manufacturing. Sussex County, the southernmost county, has a rental market shaped by beach tourism and the retirement community. Rehoboth Beach, Dewey Beach, Lewis, and Bethany Beach have seasonal tourism markets with workforce housing demand during the summer. The resort communities attract seasonal workers who need temporary housing. Screening these applicants requires clear criteria for evaluating seasonal or temporary income. The inland Sussex County communities, including Georgetown, Seaford, and Laurel, have more affordable markets driven by agriculture, poultry processing, and manufacturing. These communities have growing Hispanic populations drawn by employment in the poultry industry. Screening applicants from these communities involves evaluating agricultural and processing industry income, which may be hourly with variable schedules. Delaware's small size creates practical dynamics similar to Rhode Island. Reputation matters enormously, and the landlord community is interconnected. Fair housing organizations, legal aid services, and the Division of Human Relations are accessible and responsive. A pattern of discriminatory screening practices will become known quickly in a small state. Investing in compliance up front pays dividends in reputation and reduced legal exposure. One best practice for Delaware landlords, given the state's broad source of income protections, build your screening criteria around the applicant's total ability to pay rather than the source of income. If the voucher payment plus the tenant's personal contribution equals or exceeds your income requirement, the applicant meets your standard. Document this calculation for every voucher-holding applicant and apply the same income-to-rent ratio to all applicants regardless of income source. Never state, in listings, phone conversations, emails, or in person, that you don't accept vouchers or government assistance. Another best practice, given Delaware's broad fair housing protections including sexual orientation, gender identity, marital status, age, and source of income, review your application form to ensure it doesn't collect information about these protected characteristics unless directly relevant to a legitimate screening criterion. Train everyone who handles applications on the full scope of Delaware's protections. The state protects more categories than the federal baseline, and every additional category represents a potential basis for a complaint if screening practices aren't carefully designed. A third best practice, verify that your screening provider properly handles Delaware's marijuana legalization. Records for marijuana possession and use that is now legal under Delaware law should not be used as a basis for denial. If your provider returns marijuana-related records, evaluate whether the conduct is legal under current law before considering it in your screening decision. The safest approach is to disregard marijuana possession records for amounts that are legal under Delaware's current framework. Delaware limits the security deposit to 1 month's rent for leases of 1 year or more. There is no cap for shorter-term leases, Though the deposit must be reasonable, the deposit must be held in an escrow account at a federally insured Delaware institution, and the landlord must provide the tenant with the account information. The deposit must be returned within 20 days of the tenant vacating. If the landlord fails to comply with the escrow or return requirements, the landlord may forfeit the right to retain any portion and may be liable for double the amount wrongfully withheld. The strict deposit rules and 1-month cap for longer leases make thorough screening essential. For the complete guide to Delaware tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.